Critical Documents, prepared for and presented at the 2017 Square One Entrepreneurship Training Program. Square One is a program of the Center for Emerging Technologies. CET is an affiliate of the Cortex Innovation Community. Square One is funded in part by the Missouri Technology Corporation.
I am Sarah Kovenock. This is Ellie Braun, together with a plant in the back of the room, who will ask questions if you don't. We are some of the attorneys at Stock Legal, which is a law firm that focuses on the business needs of startups and small and medium-sized businesses. So forming them, helping them run on a day-to-day basis. These are businesses that are too small to need their own full-time lawyer in-house as an employee of the company. We help them grow, and we also, when time is right, help them buy or sell companies. So, and as a side note, Ellie and I both grew up with parents who had family companies and are married to spouses who are in startups or small companies. So we see it all day at work, we do it all day at home, we grew up with it. I guess that's a good segue into, I have a question that will kind of give us some context about those of you in the room. How many of you have a company? Like by show of hands, how many of you have a corporation?
Actually formed a...
Yes, actually formed.
Actually formed an entity.
Yes, okay. And then, all right, good number. And then how many of you have an LLC or legal, limited liability company? Okay, wow. So hopefully some of this will just be review for you. If not, then I'm glad we're covering it.
Well, and how many of you actually consulted a lawyer before forming your LLC? Okay, that I'm surprised by.
All right. So
kudos to you all.
So even if you're in business without a company, even if you babysat when you were younger, you mowed your neighbor's lawn, you were in fact in business. You are what is called a sole proprietor. And when you are a sole proprietor, you are your business and your business is you. And if something goes wrong, you are open entirely to being personally responsible for what went wrong with your business. So, for that reason alone, a lot of people like to set up separate, distinct legal entities, corporations, LLCs, to shield themselves from personal liability if something goes wrong with the company. And that's what separate legal entities like LLCs and corporations do, as long as you follow some few basic rules for an LLC. And I just realized I should mention that we are here today to demystify critical legal documents. We have 5 topics that are relevant for most, if not all, companies, and they make up a good portion of what we consider a strong legal foundation for a company. Now, if you lack a strong, solid legal foundation, the result is pretty much the same as if you lack a strong foundation for anything else, like your home. With time or growth, it becomes really apparent that the model you have is unstable. So I hope that you feel comfortable asking questions today. You can interrupt me or Ellie. We will try to remember at the end of each topic to ask for questions. You can grab us when we're done talking, if your questions are too in-depth or if they're covering something that I just learned will be covered next week by another presenter, we'll tell you. You're also welcome to email, call us, make an appointment to come stop by, and discuss the specifics of your situation with us. So with that said, every situation is different, and that brings me to my final point, which is that, in my opinion, you need your own legal documents for your company like you need your own pants. So you could turn to your neighbor sitting next to you today, and if your neighbor was feeling generous, maybe they would loan you their pants. But there's no guarantee that their pants would fit you. Maybe you couldn't even get into them. Maybe you could get them up, but they wouldn't cover your ass. And what we want for all of our clients is that they have tailored legal documents that fit them, their company, and the situation they're in any given moment. This also means it's not necessarily something that you can Google. I mean, you can Google everything I'm talking about today, and you might get examples of documents that are called the things that I mentioned today, but whether they are tailored to you, I'm going to pretty much guarantee that they won't be. And the foundation, legal foundation for your company is something that's too important to just leave up to Google. And hopefully, when Ellie and I are done talking today, you will understand why I say that a little better. So these are the 5 topics we're going to cover today. The first is formation of an LLC. Why an LLC? Well, for the vast majority of our startup clients here in Missouri, an LLC is the best option for a few reasons. The first is that LLCs are very flexible. You can set up the management structure of LLCs in pretty much any way that suits you. And Ellie's going to touch on that in a second. The second reason why LLCs are often our recommendation is that they are easier and cheaper to both form and to kind of keep going on an annual basis. There's no fee to the state of Missouri to continue to exist once you've formed an LLC. And that's not the case in other states, and it's not the case in Missouri with a corporation. So the third reason why LLCs are often the preferred organization is there are tax reasons. And I'm not an accountant. And like I said, every situation's different. You want a legal solution that is tailored to your situation. But generally speaking, this is why the tax situation often works out more favorably if you go with an LLC. So LLCs themselves are not taxed. Corporations are. You may have heard the term double taxation. What this refers to is the fact that money a corporation earns is taxed at the corporate level, and then from the pool of money that's left over after the corporation pays taxes, some of that money is distributed to the owners, and then that money is taxed again at the individual level, the shareholder level. So the first time and the second time, that's two, so double taxation. LLCs are not taxed, they're what's called pass-through tax entities, which means the first time that the money an LLC makes is taxed is when it passes through to the owner's individual tax return. And the other thing that passes through is not just profits, but losses can pass through. And this is a good thing because you can offset the losses with the money when you are an early stage startup, because there are losses almost always, if not always. You can offset the losses of an early stage LLC startup with the money that you're earning in your day job that you haven't quit yet. And that is not available in any way, shape, or form to the owners of a corporation. So speaking of owners of a corporation, I want to cover the lingo, and I've tried to be neutral, but there are certain terms that are used for LLCs, and I just want to cover them, and then hopefully Ellie will use them too, so that we continue this. But the owners of LLCs are called members. They are not shareholders. That's the term for an owner of a corporation. They're also not partners, but you will hear accountants call the owners of LLCs partners simply because LLCs are taxed, like partnerships, and they're thinking taxes all the time. But the legal term is members. Then each member or members owns a right to the profits and losses of an LLC, And that interest is called membership interests or units. It's kind of analogous to stock in a corporation, but not entirely, because remember I said LLCs can get the losses, and you don't have that in a corporation. Then LLCs can be managed one of two ways, and there are a million ways to set up the management within those two categories. But LLCs can be managed by the members or managed by a manager or a board of managers, which is kind of like the board of directors of a corporation. And then finally, officers is exactly what it sounds like. It's the same word used in corporations too. Officers can be appointed to carry out the day-to-day business of the company. So with that, Ellie's going to take over, and thank you.
Okay, so I am going to start today by talking about how to form an LLC. And it sounds like many of you have already passed that phase of it, but it's very simple. All you do is file what's called the Articles of Organization with the Secretary of State of Missouri. The articles don't contain much information at all about the company or about how the company is going to be run. It's literally just, it's sort of the birth certificate of the company. It's just a record of when the company was born. So, in order to put in place how the company is going to be run, you need what's called an operating agreement. And the operating agreement is the agreement that is signed by all of the members of the company. And it's an agreement on, like I said, how the company is going to be run. It's sort of like the rule book of the company. It's going to cover things like what happens if there's a disagreement between the members of the company, what happens if a member wants to withdraw from the company, what happens if a member wants to sell his interest in the company, what happens if a member dies or becomes incapacitated. So it's going to cover all these what-if situations. It's also going to set forth the different voting rights of the members, the distribution rights of the members, the different classes of units, if you have different classes of units. And then it's going to set forth how the decisions are going to be made within the company. So who's going to vote, who has the right to vote, who's going to run the day-to-day operations of the company, things like that. And as Sarah said, do you have a question?
Yeah.
Go ahead.
What if I created an LLC and I didn't have an operating agreement?
Thank you for that question, because I did that.
So that's
A
fine.
lot of people do. That's it.
So if you don't have an operating agreement, that's fine, but you should get one ASAP. We encourage our clients to get operating agreements before they start doing business, because it's harder and often a lot more expensive to try and put an operating agreement in place before or once something's gone awry. So anyway, as Sarah said, another question.
On that operating agreement.
Yeah.
You formed like the LLC in your name, but then you subsequently took on partners and created this operating agreement between you and the members, right?
Uh-huh.
That you wrote and you all signed. Do you have to do anything with that? Or can it just be, if we're all in on it, does that have to be filed with the state?
No, it does not have to be filed with the state.
Okay,
So-
so the LLC was filed with the state. Subsequently, this operating agreement was just written.
Yes.
Everybody signed and does all the rules. That covers the other people as well, even though they're not actually owners of the company based on what the state of Missouri thinks.
Well,
So the birth certificate that Ellie mentioned?
Yes.
Sorry. Oh, I shouldn't interrupt them. Okay, so the birth certificate that Ellie mentioned, the articles of organization, it doesn't matter who signs those and who files those. In fact, we usually file them for our clients. The person who does that, or the people, has no real role in the company, necessarily. It could be the same people, but it's not the mechanism by which you become an owner in the company. So all the members, though, do need to sign an operating agreement. And while operating agreements don't get filed with the state, there are outside parties who are going to want to see them. Not only do you need to know what they say to run your company on a regular basis, but it would be totally reasonable for your bank to ask for a copy of them before you open an account, for investors to want to see them. Yeah. So, and if you have a operating agreement and in place and everyone signed it, and then you take on more members, there's a
Can you just infinitely keep doing more and more like
one-pagers?
Schedules, like I'm on schedule E, like can I just keep doing another letter every time something changes?
Well, potentially.
Yeah.
I mean, everyone needs to sign and say they
Every
agree
time
to
you
it,
signature.
and then you need to update what would be called the member schedule. If it was a corporation, it would be called the cap table, reflecting the ownership
Right,
percentages.
percentages.
But depending upon how your operating agreement's written, like yes, you may have the power to just keep on adding pages.
If you write like a nice narrative, and you're just really looking to protect everybody in it, right? And if the narrative makes sense, then somebody would be able to still make the claim, right? No? Am I right?
It depends what those pages say. But yes, potentially.
Yeah. Did I see another hand?
I was just gonna ask, if it is just one person, is there anything like a substitute for the operating agreement that should be in place?
No. I mean, if there's just one member, the operating agreement's gonna be really simple. But you still do need an operating agreement.
Okay, that's I guess what I'm
Yeah, I mean, it might be like 4 pages. I mean, it will be pretty simple because if you're the sole member, you'll make every decision for the company. But you still should have an operating agreement in place. Yes,
Hi, I teach the biotrack here,
okay.
and while I strongly agree with the idea that LLC is usually, certainly for most people in this room, the right way to go, let me just ask, because it's the biotrack, is there anybody here who has formed their company as a corporation? For Tom, I know you have. Anybody else? Because
I did LLC, and then my accountant told me to change it.
Why did they say that?
Because then I would be able to pay myself a certain amount, and, which I consulted with, lawyers saying that maybe wasn't the best move. I just sort of trusted my accountant. I don't know.
Interesting. So we frequently, for us on the biotech side, we do recommend a corporation under a circumstance where the company's probably going to be acquired before they ever have any revenue. And therefore, the double taxation thing is irrelevant. And the other reason is because most companies that we work with are going to need lots of investment, which means they need to use professional investors, i.e. venture capitalists. And venture capitalists typically will not invest in an LLC. So to get venture capital, you'll have to switch from an LLC to a C Corp anyway. So that's the one exception that I would just to make sure we cover the.
Okay.
the
So
landscape
do you
there.
want us to respond to that, or do you want to ask your question, Sarah, at the back?
If I can just respond to that.
Okay. So.
Keep my mouth shut in the back here. What I think would be helpful to share with you is that, let's see, I guess it was about 8 weeks ago, I presented at the American Bar Association's Business Law Section meeting. And I participated in a panel that was made up of 4 lawyers from throughout the United States. And the sole topic was LLCs versus corporations, which you'd think we've answered that question, but we're still talking about it here today. What was interesting is that one of the lawyers was out of Silicon Valley. He built his practice on representing startups, and he brought the C Corp perspective. The C Corp perspective is essentially his clients are go big and be the next Facebook or go home. And in that go big or go home, it does definitely make sense to form that C corporation. But what came out of that panel is that so many venture capitalists now throughout the United States are investing in LLCs. And the one thing I haven't heard anybody say yet is converting from an LLC to a corporation is something that you can do very easily and with very little tax consequence.
Right.
But going backwards
You
is
can't.
very expensive.
Right.
So just to add my 2 cents to that, it's great that you point that out because we're still talking about it at the American Bar Association.
Yeah.
And not only is it easy to convert not only is it easy to convert LLC to corporation, but while in our experience it is true that investors are more often looking for corporations, we have clients right now who this week actually are getting investment in their LLC through
Yeah, it does happen.
through VCs.
You know, it's just, especially.
But you're right, it's
Because
less
then
common.
they have a duty of, informing all of the limited partners, so if it's a big fund, they don't like to do that. But then, the other thing, yeah, it's easy to change from an LLC to a C Corp, LLC to a C Corp, as long as there are no disgruntled members. And if you do have disgruntled members, needing to make that change creates an opportunity where they can hold up the works and be a nuisance. So, just as an FYI, we've had personal experience with that as well, so.
Yeah, that's a good comment because something like that would probably require the consent of all the members. I mean, depending on how the operating agreement is written, but. So if there are no other questions right now.
I just wanted to make sure we covered that in case any people in the life science track were getting confused as they were hearing something different from what they're hearing.
Yeah, and I think next week you're going to hear a whole talk on the difference between corporations and LLCs.
Oh my God, really? I didn't realize that.
Oh, that's okay, no problem.
All the schedule people are
I read that schedule, I swear to God.
Okay, so back to the operating agreement. So as Sarah said in her intro, the management structure of a LLC can be very, very flexible. So you can really set it up any way you want to. Typically, we set it up so that one person is put in charge of like the day-to-day operations of the company. And then we set it up so that the bigger decisions of the company require approval from other folks. So you can set it up, if you have a board, certain actions require approval of a majority of the board. Other actions you can require the approval of the majority of the members or a supermajority of the members. And then the biggest decisions, things like converting to a corporation or dissolving the company, typically involve the consent or approval of all of the members. But as I said, you can set it up really any number of ways, which is one of the beauties of an LLC. The LLC is also going to set forth the, do I need to switch slides here? I bet I do. No, I don't. Okay. Sorry, so the operating agreement is also going to set forth the units, the classes of units that the company is allowed to issue. And for many LLCs, if there's one member or only a handful of members, there's only going to be one class of units. So all of the members are going to have the same voting rights, the same distribution rights, etc. But if you have multiple members, if you anticipate raising equity in the future, you may want to set it up to have additional classes of units. For example, you may want to authorize what's called profits interests. Profits interests are a really valuable tool for LLCs. And what they are there units in the company that are granted to employees and independent contractors. And they're sometimes called incentive units. And they're called incentive units because the holder of the profits interests only receives a distribution for the added value that they give to the company once the units have been issued. So I'll give you an example to try and make it clear. So if I have a company that's worth $100,000 and I issue to Sarah profits interest in the company, and then next year my company is worth $150,000, when I go to make a distribution, I get the distributions up to the $100,000, which was the value of the company before she became a member, and then she and I will share in the $50,000 added value to the company. So in that way, profits interests are a really great tool because number one, they incentivize the employee to grow the company. And number two, they have no value until a distribution is made. So the incentive holder has no tax consequence until he or she receives a distribution. So those are the basics of the operating agreement. It's going to set forth the what-ifs of the company, how decisions are made in the company, and the classes of units in the company. And then you'll also have to set up an EIN number which is really easy. It's like an online filing. It takes 5 minutes to do, but you will need that as well. Does anybody have any other questions about forming a company or operating agreements? Yes.
Would you consider profit interest a way of compensating using equity?
Yes, exactly.
So does everybody know what I mean by that? Okay, so it's a way that you're able to compensate someone, which we usually think of in terms of salary, right? Using equity ownership in the company without actually vesting ownership
Yeah,
at the time of, say, hire.
yes.
There are different ways that you can use equity to compensate people.
And you can,
build incentives in so that they meet certain goals in order to earn that equity.
yeah, and you can set it up so that the interest will vest a year from now, or as Christy said, after a certain milestone is reached or after a number of milestones are reached. So yeah, that's exactly what I'm talking about. They're incentive equity in the company. And yeah, you can set them up under any vesting schedule. Do you have anything to add to that? Okay.
I'm in charge of the time.
Oh, okay. I know. We're running. We're already running low on time.
Yeah.
Okay. All right. You know what?
All right.
So we have 15 minutes left in total. Okay. All right. So confidentiality agreements.
Sorry.
Well, and we're asking questions along the way. So
Okay. Okay.
I'll yank it. Don't worry.
Okay.
When you say distribution, it means sale of property or sale of money made?
So distribution is just.
Set up either way.
Yeah, I mean, it can be from the sale of a company, but it can be a periodic distribution. So if you've made enough money in a given year, and instead of keeping it in the company, you want to distribute it to the members, that's called a distribution.
Also, owners aren't paid as employees, so their payment is considered a distribution. And your operating agreement would specify how often that distribution is made.
Yes.
Usually a meeting and an agreement, if you're the only person, you meet with yourself, you agree on the distribution.
Right.
But that's how you're leaving the wage earner land and you're going into a different way of being compensated.
Yes, if you've always done been like a W-2 employee, it's going to be a little different if you are working for an LLC that you own.
Okay, so confidentiality agreements, I'm going to go through super quick since it feels like we're already running low on time. They're fairly straightforward. It's an agreement between you and a party that they will keep whatever information you provide to them confidential. The two main things you need to look at in confidentiality agreements is the definition of the confidential information. You want to make sure it's covering what you're giving them and what you want kept private, and the purpose for the way that they can use the confidential information. So you'll limit how they can use the confidential information to a specific purpose. And that's all I'm going to say about confidentiality agreements unless anybody has any questions.
Could you just run through the flavors there real quickly?
Yeah, so these are just things, these are parties that we provide NDAs for our clients on a regular basis. So for a potential investor, for a potential employee, potential independent contractor, general contracting, and for a buyer of your company. And then what's in the parentheses here is what we would propose would be the permitted use. So the way that they can use the confidential information. So like for a potential investor, it would say that the recipient can use the confidential information solely for the purpose of an investment consideration.
And do you use NDA and confidentiality interchangeably?
Yes. Yeah, you may have heard non-disclosure agreement, confidentiality agreement, mutual non-disclosure agreement. The title of the document is pretty interchangeable. They don't really mean, it doesn't matter if it's an NDA or a confidentiality agreement. Okay, so moving right along to how to engage employees and independent contractors. So first step is often to get a confidentiality agreement. The second step is going to be to determine how you're going to hire these people. Are you going to hire them as an employee or an independent contractor? And it's cheaper for companies to hire people as independent contractors because you don't have to pay benefits for them, including insurance. You don't have to pay them a salary, pay them on a project-by-project basis. You don't have to pay employment taxes, etc. But there is an effort by the IRS and the Missouri Department of Revenue to crack down on companies who are using people who should be employees as independent contractors to save money. So the Supreme Court of Missouri has put out a 20-factor test, which I'm not going to go into right now, but you can look it up. Most of the 20 factors are concerned with the amount of control that the company has over the company, so over the employee or independent contractor. So the more control, the more that person should be considered an employee. Whereas if there's more freedom, that person will be considered an independent contractor. So if you decide that you want to hire an employee, you need an employment agreement. Now, Missouri is an at-will employment state, which means that a person can be fired or terminated or quit at any time for any reason. So some people think that that means that they don't need an employment agreement with people because they can just fire them whenever they need to anyway. But that's not true, because an employment agreement should contain other provisions that are really important to the company. So those are, number one, a confidentiality provision, which will cover the same thing as an NDA would. A non-compete provision, which says that the ex-employee will not compete with the business of the company for a specific amount of time in a specific geographic location. Non-competes are a little tricky, so you need to be careful when you draft them that they're reasonable in scope, because if they're not considered reasonable, they'll be struck down by the court. So that's a consideration. Another provision that should be included is a non-solicitation provision, which says that the ex-employee will not try to solicit your customers or your clients or your other existing employees for a period of time. And then lastly, an invention assignment. This is a really important provision. It says that the employee will not, the work of the employee that's done while he or she is employed by your company is owned by your company. And this is, of course, very important because you don't want an ex-employee going to a competitor or starting their own business with something that you paid them to create. So those are employment agreements. If you do decide to hire somebody as an independent contractor, so there will be some of the same provisions. It will contain a non-solicitation provision. It should contain a confidentiality provision. It should contain an invention assignment. It may contain a non-compete, but those are even harder to enforce against independent contractors, so that's something that you'll want to give some thought to if you get there with your attorney. But a couple different provisions that an independent contractor agreement should contain are an insurance provision. So the actions of one of your employees will be covered by your company's liability insurance. The actions of an independent contractor may not be covered, likely will not be covered by your company's liability. So you may want to include a provision requiring the independent contractor to get his or her own insurance and naming your company as an insured. And then the last thing is the independent contractor agreement should contain a provision stating the relationship of the parties as that of an independent contractor. And it should also contain the reasons why you chose to treat that person as an independent contractor. And the reason for that is just in case the IRS ever does knock on your door, having a written agreement in place that states why you chose to treat that person as an independent contractor can go a long way. So I went through that very quickly, but does anybody have any questions? Yes?
What if your contractor doesn't have insurance on their own?
Well, that's going to be a business decision for you. I mean, if that person is very important to you and you want to take the risk, then you can.
So there must be insurance, and maybe you just not insure the contract, something happens.
Say that again?
Insurance, or what kind of insurance are you talking about? Health insurance, or?
No, just like general liability insurance. So that if something happens while.
Not
Well, it depends on who gets sued, but the company will likely get sued for that, just because the company is it's gonna be perceived that the company will have more money in the bank. So they'll probably be the party that is sued, which is why it's a good idea to require them to get their own insurance. Because there'll also be an indemnification clause, which requires the contractor to indemnify your company, if you get sued for something that they did. And indemnify means that if a third party sues your company, the contractor will have to reimburse you for whatever loss you incur, including attorney's fees. You have anything to add to that?
I mean,
Okay.
Just to be clear, the language was used of if you choose to hire an independent contractor, that 20-point factor test should determine whether or not you do that. Just wanting to hire somebody as an independent contractor is not sufficient.
Or calling them one.
Or
You're
just calling
agreeing
them
on
one,
it doesn't
or,
mean-
you know, there are very specific things you have to do. So I just want to be clear that that choice is not yours to make alone.
And also, if it seems fuzzy, it kind of is. Anything that has a 20-point factor test is not clear. That is not normal in the law.
Yeah, I mean,
That's where we are.
it's going to be a balancing test, sort of, based on.
That's why you need good counsel.
Yeah, and it's strictly looked at by the Missouri Department of Revenue, so you do need to be really careful about it.
so I'm going to cover the last two topics in the next 5 minutes or whenever I get kicked off. So no, we're good. Questions are helpful. There's no point in being here if you and not understanding. It's a waste of everyone's time. So we talked about forming your company. We talked about getting someone to help you, an employee or an independent contractor, once your company's grown beyond what you can handle. We're missing a key component of successful companies, and that is customers and potentially suppliers, depending on what your company does. So when you are contracting with customers and suppliers, you may want a confidentiality agreement. But the crux of what I want to talk about general contracting is our master services agreement. So this is like a template agreement that we provide to our startup clients that they can use repeatedly in life situations. So say that you have a consulting business, and the nature of this business makes sense that you should contract with your customers, and you're doing consulting work for all of them, but the exact specific nature, the timeline, whatever, of your work with each customer is a little different. So this template is perfect for you. The master services agreement is divided into two parts. The first part is the legal part. We would write that. And the second part is a schedule of work, and that's where you would put the details of what's specific to your work for a certain client, and so that would change. But because we've already handled the legal part in part one, you don't need to necessarily come back to your lawyer every time you're contracting with a new customer. So this is just an efficient way to to protect yourself with a master services agreement, but keep your legal fees down. Of course, every situation is different. If you change something, if something feels off, you should consult with your lawyer. But for the vast majority of our clients, this works again and again. So in this, what goes into the legal terms in the first part? This is things like payment terms, the term of the contract, or how you get out of the term of the contract is the length of the contract. How would you get out of the contract before that time period is up, and what are the events that would cause you to be able to do so? There would be a limitation of liability spelled out in it. That's a term that basically means what's the maximum amount that you would have to pay if something went south and it was determined that it was your fault. Certainly you want to spell out what that limit is, because unlimited is a lot larger than a capped amount. Another important thing in the master services agreement would be language assigning the intellectual property. So in this example, you're a consultant. Let's say you have some kind of algorithm or that you figured out that is what really sets you apart as a consultant. So the deliverable that you'd hand over to any given client would contain information that you kind of ran through this algorithm, but you don't want to hand over the entire algorithm to your client. You, this assignment of IP would say that you maintain that embedded intellectual property, that algorithm, and you license your customer, give them the right to use it in the end product for as long as they need to. So you could see how these things probably won't necessarily change from customer to customer in this consulting example. The schedule of work, the second part, is what changes. That's where you detail what are your milestones, what's your final deliverable going to look like, how are you going to work together, because you can't just divine the information you need about them. You need to know how you're going to get this information. Say a specific customer, you finish a project for a specific customer and they love it and they want to hire you to do something else. You don't have to start from scratch. You've already have this master services agreement that you've agreed to. Write up a new schedule of work. Both of you agree to it, and you tack it on the bottom behind the first schedule of work, and you're done. So this is, I think you can see how this would be a very efficient means of contracting rather than starting from scratch each time. Now, in my example, you were using a master services agreement with your customers. The nature of your business might be such that you should also use a master services agreement with your suppliers. Remember, tailored documents, tailored like pants, don't just swap them out because they have the same name. When you are the supplier of services in a situation, your master services agreement should be tailored to you, favorable to you in that situation. And the same is true when you are the customer in a situation. That's why you can't just flip-flop because they happen to have, these contracts happen to have the same name. Any questions about contracting, general contracting? Okay, can I continue? Do I have enough time? Okay, so the final topic that I want to cover is capital raises. So, and to do so, I need to talk about securities. What are securities? So securities are proof of ownership or debt, for example, stocks, bonds, options, and in this case, if you remember when I went through the LLC lingo, we're talking about membership interest in an LLC or units. If you want to raise money for your company and take on additional investors, you are going to sell securities. And this is important because of the Securities Act of 1933, which, among other things, says that if you're selling securities in this country, you need to register the sale of that securities with the Securities and Exchange Commission, the SEC, which is as time-consuming and expensive as it sounds like it might be. And the upshot here is there are some exemptions in that Securities Act of 1933 that allow for unregistered offerings or private placements if you meet certain criteria that are spelled out in the exemptions. I'm not going to go through the exemptions, but basically they kind of boil down to two things, two components that allow you to not have to register with the SEC. First, accredited investors. You are taking money from people who meet certain people or companies who meet certain financial criteria, either with respect to their net worth, their annual income. It's spelled out like down to the dollar amount. The thinking here is that accredited investors are a little bit more protected or insulated by their money than the general population. So the second component that lets us kind of guide our clients through these exemptions and not have to register with the SEC is that the company issuing these securities has to disclose all material information. What's material? Well, it's anything that an investor would want to use to make a decision about investing. So you can be assured that if there's a piece of information that you do not want people to know about your company, it's probably material and you have to tell them. So that's never fun, but this is important because of personal liability. If you remember at the beginning, I said you set up a separate distinct legal entity like an LLC or a corporation to shield yourself from personal responsibility or personal liability. And if your company sells securities and something goes wrong and it's determined that you didn't disclose material information, then guess what? You could be held personally liable for that. So that's why that second component, the disclosing material information, is super important. We, like I said, guide our clients through capital raises and make sure that they meet these exemptions so they don't have to register with the SEC. And we do that with what we call a subscription package. It's a group of documents which, oh, surprise, surprise, includes a non-disclosure agreement somewhere in there. Well, it's not written, but it should. So non-disclosure agreement might have been on the previous slide. Can't hurt to ask. Will every investor sign one? Maybe not, but there's no harm in asking. Second thing is a term sheet. This is a sheet with the key terms of what you're offering, and you can kind of socialize it or shop it around and see if there's any interest in what you're selling. But the umbrella subscription package is the key set of documents by which we meet the exemptions and don't have to register. The subscription package includes a subscription agreement. So that's a relatively short agreement by which your investor purchases the securities and your company sells the securities. And then tacked onto that subscription agreement are some number of exhibits, and each of these exhibits helps meet one of the two big criteria: accredited investor or material information is disclosed, that makes certain that you stay within these exemptions to the securities laws. So one of the exhibits is the operating agreement, which Ellie talked about. So all of your investors are going to be bound by it when they become members of your LLC. They better see it. There's a quick one-pager, which might be what Matthew was alluding to with the whole tacking on pages to his agreement, that basically your investor would sign and says, hey, yeah, I read that operating agreement and I agree to be bound by it. And then you tack it on and you have record of everyone who's agreed to the operating agreement. The next thing, risk factors. This is pretty obviously goes to meeting that material disclosure requirement. When we help our clients do this with an umbrella subscription package, we start with a document that's talks about risk factors in general and has at specific points in this document blanks or like comments about where our clients can add information about risk factors specific to their company and their industry, because our clients are the experts in their business and their field, and we kind of guide them through adding risk factors that are relevant there. I'm going to skip the next one. There would also be a business plan, which I'm guessing you're helping all of them write. There'd be projected financials, and then there'd be sources and uses. How are you going to use the money that your investors are paying you for these securities? When our clients don't have this set up, we just email them we have a simple blank Excel spreadsheet that kind of prods them into, hey, start thinking about these things and fill in the blanks. All those exhibits that I've mentioned so far go to the material disclosure aspect of the exemptions. And then the final thing, which is somehow stuck in the middle, is the investor questionnaire. That's a questionnaire that the investor completes. It says how much money they have, and you can be assured that that you've asked the right questions to know that they are accredited investors and you meet the criteria. So that's, in a really quick nutshell, everything that goes into an umbrella subscription package. But if I have 2 more minutes, I want to compare it to yes?
I do have a question.
Yeah.
Can you target nonprofits as investors, or is there a different law or rule?
So if you wanted to get in this exemption and sell to accredited investors, there are different criteria that each have to meet, whether you're selling to an individual person, a couple, or any kind of entity, including a nonprofit. And so they just check the box where with like, which of these are you, and they hopefully check the box, and then you know they're accredited. Any other questions? Okay, So I just wanted to quickly compare this umbrella subscription package to a private placement memorandum. I think people have heard of this more often than this private placement memorandum more often than they hear of subscription packages. So in the subscription package, I explained while we're working on this that it's kind of like a collaboration between the lawyer and the client, with the client providing some of the information and the lawyer kind of guiding, but recognizing that their clients are the experts in their own business. So the way that a umbrella subscription package contrasts with the private placement memorandum is that the private placement memorandum is compiled pretty much entirely by the attorney. So they get all the information, they do some diligence, which is like just a fancy lawyer word for investigation, and spending a lot of lawyer time. With reason, but because they need to know, they're producing this document, they need to know and be certain that what they're saying is true. And so they go through that, then they produce a big thick document that is the private placement memorandum. So as you can imagine, the legal fees for preparing a private placement memorandum are a lot higher because it's not this collaboration between the lawyer and the client. And that's why a lot of our startups love the subscription package, because it's relatively cheap. Well, it's a cheap way to raise money, such that even if you're raising a small amount, it's okay. You're not going to have to raise the money and then turn around and pay the entirety of it for your legal bills. It's just going to be a tiny little fraction of it. So we work with startups every day, and we know that there is a lot competing for the time, attention, and money that startups have, and that all those resources are limited. But hopefully the things we've touched on today make it apparent why spending a little bit of that time, money, and attention early on to get a solid legal foundation makes sense and will save you in the long run. Any questions? Yes?
So what else do you guys offer for somebody who may or may not have formed an LLC without legal advice? What would you offer besides?
You're not alone.
Just hypothetically speaking. I have lots of them. What else would you offer? So is the umbrella subscription package, does that include things like helping me get an operating agreement together, or some of the generic NDAs for people that I'd be talking to? Or is that kind of separate? Or how does that work as far as I'm poor but need help?
So if you got the packet, what?
So this is when you need to talk about our fixed fee.
Yeah, I know. So if you wanted the umbrella subscription package, it would not include the price for it, would not include an operating agreement, but it would be a necessary step in getting to be able to sell securities, because your investors would want to see an operating agreement. So as the commenter in the back alluded to, we do offer a number of fixed fee documents or packages for our startup clients, and this is a way of just knowing ahead of time, before a single minute of lawyer time is put into you, exactly how much your bill is going to be at the end. And so it's really just like ordering off a menu, and then we clearly define, okay, for this much money we will help you get an operating agreement, or if you have one in place but it's not tailored to your needs, then we will amend and restate it, which just means starting over. But with the appropriate legal words, we'll start over and put one in place that does suit your needs. It's very common for people to come to us with their legal documents and their legal foundation in various states of being built up or just disrepair. And so it's a common ask when clients come to us, is to tell me what I have, tell me what's wrong with what I have and why, or what's good about what I have and why, and then help me get everything on track.
And the other thing about our fixed fee packages is that we give you a form that you can use for the future. So we'll give you a form if you hire us to do an employment agreement. We'll give you a form for that. So then hopefully the next employee that you hire, you can just change the date and name, and then the exhibit, which will have the specifics for that employee. Same with an NDA, the independent contractor agreement. So we try and put you guys in a position where you can do some of these documents on your own, without having to come back to us every single time.
So you kind of pick and choose the things that you need, and then this is something that goes on top of that in order for you to.
Yeah, so if you're looking to raise capital. Yeah, and then we do, I mean, we help, oh, no. We have we help businesses with any transactional work, any business work. So there's a whole range of things that we do that we haven't mentioned today, but this is what we think makes up the foundation. And we do all the equivalent things for corporations. They don't have articles of they don't have operating agreements, they have bylaws, they have shareholder agreements, they have investor rights agreements, things like that. And the subscription documents look the same for corporations, pretty similar.
Great, thank you.
Thank you so much.
Thank you.